Already, let me start with the previous conviction that we faced before this court. And on the 14th July 2023, Supreme Court of Appeal granted a leave to appeal the full court for KwaZulu-Natal of the High Court of Magistrate. So those previous convictions that are placed before this court are subject to this order from the Supreme Court of Appeal, which is going to be held in future. I just want to place them.
Okay.
Let me deal with
When was the leave to appeal granted?
to the full court of KwaZulu-Natal.
The date?
The date is 14 July 2023.
Yes, it's okay.
Let me quickly deal with the personal circumstances of the offender. Mr. Nemo was arrested sometime in October 2018. He was born in 1988, January the 1st. Mr. Nemo has 4 minor children. The first one is 14 years old, a girl. The second one is 18-year-old boy. The third one is 11 years old boy. And the last one is 10-year-old girl. This level of education, my Lord and my assessor, is grade 10. His family background is that he has his mother is still alive, and his father died some time ago. He was supporting his mother, who is 76 years old. He was also supporting his 4 minor children. He used to be self-employed as a man who was selling head meat. Selling the head meat. His health, he is unwell. But he is on treatment. My lady and my learned assessor, upon his arrest in 2018, Mr. Nwa accepted or confessed to these serious charges. It is evident from Section 220 admission that he did call the Magaqa family to apologize. He did advise me that he attempted to get the contact details of the survivors and those whom their vehicle were damaged to apologize. Unfortunately, he did not get their contact details. Mr. Nwa pleaded guilty of these charges.
He admitted to the charges after having pleaded not guilty. That's correct.
That it can be so, my lady. But also, my lady, it is evident from Section 220 admission that he did attempt to plead guilty in 2018. My lady, those are the personal circumstances of the accused. My lady, in this stage, the starting point is that there is prescribed minimum sentence in terms of Section 51 of Criminal Law Amendment Act. My lady, Section 51, subsection 1, deals with life imprisonment of planned murder. And Section 51, subsection 3, it says as follows: unless the court can find the existence of substantial and compelling circumstances which justify the imposition of lesser sentence, the court will consider these factors together with other relevant factors. Now, I will deal with those factors that I will argue that they qualify to be substantial and compelling factors. Firstly, my lady and my learned assessor, it is important to show this court about what is a life imprisonment. My lady and my learned assessor, in Mashego and another, the following was said, versus state, which is case number 20108/2014. Paragraph 26. It reads as follows: it is correct as counsel for the first appellant submitted that imprisonment for life, which is the ultimate sentence, should not be lightly imposed. It is the kind of sentence that should be imposed only after due consideration of all the facts and circumstances relevant to the sentencing, in particular the life history of an accused, his or her upbringing, his or her career, if any, prospect of rehabilitation, and of course the nature, impact, and effect of the offense of the complainant. My lady and my learned assessor, when dealing with the sentence, the court has to bear in mind that there is no onus placed on the accused person to prove presence of substantial and compelling circumstances. However, there is a duty on the accused to produce evidence in order to convince the court that circumstances exist which justify the imposition of the lesser sentence. My lady and my predecessor, personal factors of the accused were placed before this court. I will now deal with those issues that I will argue that they qualify to fall under subsection 3, section 51 of the Criminal Law Amendment Act. My lady and my predecessor, we know that the accused was arrested in 2018, and from that time he wanted to plead guilty. So far, he spent 8 years waiting for this day. This affects my lady. In the previous cases, it has been regarded as substantial and compelling fact. My lady, the accused pleaded guilty, which he showed remorse. My lady, there is a case from our division, State versus March, 2014, volume 2, SACR 298, in brackets, KZN, at paragraph 27. Judge Gogan said the following: even though the accused plea of guilty was little moment because he was caught red-handed, it counts as something that did not unduly burden the state with the need to prove the charges, and had furthermore expressed remorse and attempted to make some recompense. My lady and my predecessor, the accused is available to assist in the state in future. My lady and my predecessor, the accused did not only plead guilty, he fully disclosed who are the instigators. My lady, let me now consider the aggravating factors on behalf of the accused. My lady, this kind of murder is very prevalent in our division. It is a serious crime. It was well planned. And the accused has previous conviction. The victims were very vulnerable. The motive of the killing was because the deceased wanted to report a corruption. I'll now argue for the mitigating factors. Even though my lady, the accused, was found guilty based on common purpose, the AK-47 that shot the deceased and the survivors, it was not in the hands of the accused, it was in the hands of co-accused. The accused has family dependents. Basis on his level of education and what is contained in Section 220 admission, I will submit, my lady, that he has subnormal intelligence. The motive here was for him to get a financial need. He waited for 8 years in custody before finalization of this matter, whereas his aim from the beginning in 2018 was to plead guilty once and for all. Now, the question before the court is, what sentence can this court impose on the accused? Having regard to the 8 years spent before sentencing, I tried to get case law of a prisoner who has 8 years awaiting for trial. But all I get about those who spent 4 years prior sentence. Director of Public Prosecution, North Gauteng, Victoria versus Wala and others. 2014, Volume 2, SSCR 337, dated 31 March 2014, Supreme Court of Appeal. In this case, my lady, there was a contract killing of the deputy mayor. All 3 accused were in custody for 4 years awaiting. Trial court imposed 12 years. And then the Supreme Court of Appeal imposed 20 years. After consideration of 4 years spent as an awaiting prison. So in our case, it is 4 times 2 now. 8 years as an awaiting. respect, submit that this 8 years must be taken into account, because if it is ignored, he will suffer twice. My authority for that he will suffer twice, I find it in State versus Stephen and another, 1994, volume 2, SACR 163 W in brackets at 168F, which reads as follows. I would agree that there is force in Mr. Duplessis' submission based on the Canadian decision of Gravino in brackets 70/71, 13, crime LQ 434, which the paragraph reads, the sentence reads as follows. Imprisonment while awaiting trial is the equivalent of a sentence of twice that length. So I respectfully submit that there are compelling and substantial circumstances to deviate from minimum sentence of life imprisonment. Most important, my lady, this court today, we know who are the instigators. So Mr. Nwa fully disclosed and honestly disclosed what happened. In conclusion, my lady, I've proposed this order that on count 1, the accused be sentenced to 20 years imprisonment, of which 5 years is suspended for 5 years on condition that the accused is not again convicted of murder, assault, grievous bodily harm, attempted murder, and assault. With regard to count 3 to 5, I propose, my lady, that 5 years imprisonment for attempted murder. With regard to count 6 to count 8, I propose that 3 years imprisonment each. Count 9, I propose 5 years imprisonment. Count 10, I also propose 5 years imprisonment. And count 11, I propose 1 year. I further propose that the sentence on count 3 to 11, 2.3 to 2.11 will run concurrently with the sentence imposed on count 2.2. I further request this court that in terms of section 280 of CPA, the sentence imposed above run concurrently with the sentence imposed under case number CC 54/2018.
Which case is that?
The one that they read the previous conviction, my lady. I further propose that the accused be declared unfit to possess a firearm. And finally, I request that the accused serve his sentence at Westville until the finalization of the other matter. This is where he advised me that he will feel safe. Those are my submissions.
Yes. Thank you, Mr.